Start. Leave granted para. Appellant herein challenges judgment and order dated 23rd January 2018 passed in Criminal RP number 1111 of 2011, whereby the High Court of Kerala allowed, only in part, his revision petition against the judgment and order of the learned Additional Sessions Judge, Thrissur, dated 11th January 2011 in Criminal Appeal number 673 of 2007, which, in turn, upheld his conviction, as handed down by the learned Judicial First Class Magistrate, vide order dated 14th August, 2007 in CC No.51 of 2003, under section 138 of the Negotiable Instruments Act, 1881, stop para. The sole issue that we are required to consider is, whether, a criminal proceeding can be initiated and the accused therein held guilty with natural consequences thereof to follow, in connection with a transaction, in respect of which a decree by a competent court of civil jurisdiction, already stands past para. The facts necessary to put into perspective the issue in the present appeal are: the appellant borrowed rupees 2 lakh from the complainant, K.P.B. Menon Shreyas, with the promise that he would repay it on demand. On receipt of such demand, he issued a check dated 30th June 2002 for the said amount from the South Indian Bank, encashment thereof was to be through Canara Bank, to which the check was sent through the post with a covering letter dated 24th September 2002. It was dishonored due to insufficient funds and payments stopped by drawer. The complainant came to know of such dishonor and issued a notice of demand dated 22nd December 2002. Accounting for no action on the part of the appellant, the complainant, the subject matter of the instant proceedings came to be filed para. Equally, though the appellant accused had filed original suit number 1338 of 2002, the 5 parties implicated as defendants were K.P. Bhaskar Menon, K.P. Vipender Kumar, Praveen Menon, the manager South Indian Bank Limited via Crl.R.P, Thrissur, and N.T. Raghunandan, stop. The prayers made therein were to: A. Declare check number 386543 of the South Indian Bank Limited, as a security check. B. Issue mandatory injunction directing the first defendant to return the said check. And C. Issue a permanent prohibitory injunction restraining defendants 1 to 4 named herein above from taking any steps to encash the said check. The Additional District Munsif decreed the suit on 11th April 2003 in favor of the plaintiff accused. The suit in respect of defendant number 4, namely the manager South Indian Bank, was dismissed and the suit was wholly decreed against the remaining defendants. Defendant number 1 filed an appeal before the additional subordinate judge in CMA number 6 of 2006, stop. In its judgment dated 30th January 2007, the court observed that the lower court correctly analyzed the facts and arrived at the right conclusion. I find no reason to interfere the order of the lower court. Hence, I dismissed the appeal. Therefore, it appears from the record that the very same check was in issue before the civil court, and also the court seized of the section 138 NI Act complaint. The conclusions drawn by the courts below, subject matter of the instant lease, are as under. The trial court convicted the appellant herein to undergo simple imprisonment for 1 year as well as pay compensation of rupees 2 lakhs in default whereof he was to undergo further simple imprisonment for 6 months. Stop. The determination of the issues, that is, whether the decree passed by the municipal court would be binding on it, is of note. Stop. It was observed that a court exercising jurisdiction on the criminal side is not subordinate to the civil court. Further, it was held that order was an ex parte order. As far as criminal complaint is concerned, the order of injunction issued cannot be granted and the hands of the criminal court cannot be fettered by the civil court. The first appellate court framed primarily one point for consideration: whether the check was issued against a legally enforceable debt, thereby attracting the offence under section 138 of the NI Act. The point was held against the appellant and therefore, the conviction handed down by the court below, accordingly confirmed. The High Court in revision observed that no perversity could be indicated in the concurrent findings of the trial court and first appellate court. The same was dismissed. We find the manner in which this matter has travelled up to this court to be quite concerning. We fail to understand as to how a civil as well as criminal course could be adopted by the parties involved in respect the very same issue and transaction, in these peculiar facts and circumstances. In advancing his submissions, Mr. K. Parmeshwar, learned counsel, appearing for the appellant, placed reliance on certain authorities of this court. In M.S. Karamchand Ganga Prasad and another versus Union of India and others, this court observed that it is a well-established principle of law that the decisions of this civil court are binding on the criminal courts. The converse is not true. In K.G. Parameswar versus Inspector of Police and another, a bench of 3 learned judges observed that following the M.S. Sharif versus State of Madras, no straitjacket formula could be laid down and conflicting decisions of civil and criminal courts would not be a relevant consideration except for the limited purpose of sentence or damages. We notice that this court in Vishnu Dutt Sharma versus Daya Sapra had observed as under. It is, however, significant to notice a decision of this court in Karamchand Ganga Prasad versus Union of India, wherein it was categorically held that the decisions of the civil court will be binding on the criminal courts, but the converse is not true, was overruled therein. The position as per Parmasankar within bracket Supra is that sentence and damages would be excluded from the conflict of decisions in civil and criminal jurisdictions of the courts. Therefore, in the present case, considering that the court in criminal jurisdiction has imposed both sentence and damages, the ratio of the above referred decision dictates that the court in criminal jurisdiction would be bound by the civil court having declared the check, the subject matter of dispute, to be only for the purposes of security. In the view of the matter, the criminal proceedings resulting from the check being returned unrealized due to the closure of the account would be unsustainable in law and, therefore, are to be quashed and set aside. Resultantly, the damages as imposed by the courts below must be returned to the appellant herein forthwith. The appeal is allowed in the aforesaid terms. Hence, the judgment and order passed by the additional sessions judge in Criminal Appeal 673 of 2007, which upheld the conviction, as handed down by the learned Judicial First Class Magistrate in CC No. 51 of 2003, which came to affirmed by the High Court of Kerala in Criminal R.P. number 1111 of 2011, is quashed and set aside. Pending application or applications, if any, shall stand disposed of. Stop.